Students, I welcome you all to lecture number 9 of Criminal Law Basic Concepts. This is a part of Clat lecture series sponsored by Sri Jendra Rank Zone, and I am your mentor Shekhar Gehlot. Now in the previous lecture, we discussed the difference between murder and culpable homicide. Okay, murder and culpable homicide. Now we will see some exceptions to murder. What are the exceptions of murder? Okay, and what are these exceptions? Okay, when we talk about exceptions, when we talk about exceptions to murder, we mean that the act or the crime which is committed has all the ingredients of the murder. Okay, the ingredients of the murder were injury has to be there, nature of injury, intention of inflicting that particular injury. We discussed that there are two type of crimes of killing a man. Okay, if you have inflicted an injury and injury's nature is such that it is sufficient to cause the death in the ordinary course of nature, and that injury has been inflicted intentionally by you, then it will become a murder, and murder carries a higher penalty. Okay, the minimum sentence in offense of murder is life imprisonment, and the maximum sentence is death penalty. Okay, and we also discussed a case which is called culpable homicide. Okay, culpable homicide. Now we discussed that when by your act or when by someone's act another person has died. Okay, but your act does not have all of the ingredients of murder. Okay, when your act doesn't have all the ingredients of murder, then it will be a culpable homicide. That means yes, you have killed someone, but you have not murdered him. Murder is a grave offense. Okay, killing someone is also a grave offense. Okay, but murder has been treated differently from culpable homicide. Okay, because murder involves a great deal of mental element, a great deal of planning. You plan and then you kill someone. That is a murder. In a very short sentence. Okay, you plan and you kill someone. That is called a murder. Unplanned murder. Okay, a murder which happened. Sorry, unplanned killing, a killing which happens but was not planned, but it has happened now. Okay, that will be culpable homicide. Okay, so there are two classes of killing a human. One will be murder if you are planning it, and if you are executing it as per your plan, then it will be murder and it will carry a higher penalty. Okay, higher penalty is life imprisonment, life imprisonment to death sentence. Okay, but when we talk about culpable homicide, it is similar, like it is killing someone but not murder. So sentencing is minimum is 10 years, 10 years imprisonment, maximum is life. Okay, maximum is life. So now when we talk about exceptions to murder, okay, exceptions to murder, like we discussed the exceptions to crime. Okay, exceptions to crime said provided you somehow immunity, kind of an absolute immunity in some cases, that there won't be any case on you if you are committing a crime in those circumstances. Okay, But exceptions to murder is not like exceptions to crime. Okay, exceptions to murder is if an act is committed due to which someone is killed and the act has all the ingredients of murder. You have committed an act, and due to that act, someone has killed, and that killing has all the ingredients of murder. Okay, so naturally, if your act has ingredients of the murder, all the ingredients of murder in occurring at the same time, then definitely you will be guilty of murder, and sentencing is to be minimum life imprisonment and maximum is death sentence. Okay, but this says exceptions say that if you have committed an act in which someone has been killed, and the killing has all the ingredients of murder, but your crime falls within the exceptions to murder, then it shall be treated like culpable homicide only and not murder. Okay, so this is the import of exceptions when we talk about exceptions of murder. Okay, exceptions of murder do not allow you to kill someone. It is not a license to kill someone. Okay, it is only that though your act is a murder, but it will not be treated like a murder. It will be treated like a culpable homicide if you have certain kind of exceptions. If you can fall your case into any of the exceptions which we are going to discuss now. So this is the exception to murder. It should not be confused with exceptions to crime. Okay, it does not give you any immunity at all. It only lowers down the culpability. Culpability means your criminal action is lowered down to the grade of homicide rather than murder. Thereby, you can have the benefit of lesser sentencing. Okay, you can be sentenced to 10 years or life imprisonment. But in the murder, minimum sentence is life imprisonment and maximum is death sentence. So you can understand there is a day night difference between the sentencing when it comes to both the category of killing a person. So now let us discuss the exceptions. Okay, the first exception to the crime of murder is death caused due to grave and sudden provocation. Okay, death caused due to grave and sudden provocation. Now, what is a provocation? Provocation simply means, literally, it means doing something at the instigation of someone else. Provocation means you are doing something at the instigation of someone else. Someone else instigated you to do something and you did that. That is called a provocation. Okay, but when we deal about the exceptions to murder, we are not dealing with only a provocation. Okay, that you did something on being provoked or being instigated by someone else. Okay, we are talking about a provocation which is grave and sudden. Which is grave and sudden. Okay, it is not an ordinary provocation that someone told you something and then you did that thing. No, it is a provocation which is so grave and so sudden that you ended up killing someone. Okay, that you ended up killing someone. Now let us see what grave and sudden provocation is all about. The death happening due to the acts done under the influence of grave and sudden provocation is an exception to the section 300 of IPC. Section 300 of IPC defines murder. Okay, it is that section which defines murder. So, the death happening due to acts done under the influence of grave and sudden provocation is an exception to the section 300 of IPC. That means if you are killing someone, someone is getting killed due to grave and sudden provocation, then his act will fall in the exception to section 300. When the accused is suddenly provoked by any person, and that provocation makes the accused to lose his control, which ultimately leads to the death of the person who provoked or any other person by mistake or accident, then the accused will not be liable for murder but only for culpable homicide. Okay. Now it says that someone, and it is usually the one who ultimately got killed. Okay, someone, usually the one who ultimately got killed, provoked another in such a manner that the person being provoked lost his sanity and ended up killing either the one who provoked or by another due to accident or mistake. Okay, due to accident or mistake. Someone is provoking you in such a manner that you are now ultimately lost your senses. Okay, someone has provoked me so much that I have now lost my senses and I end up killing the other person. Okay, I end up killing the other person or someone else, when someone else, because I'm trying to kill the person who provoked me. Okay, suppose I'm trying to kill the person who has provoked me, but somehow he escapes and I end up killing someone else. Suppose I shot at him. Okay, I shot at him, he evades, and the bullet hits someone else and he dies. Okay, or I attack him with a spear, he dodges and someone else dies. Okay, something like this. Okay, due to accident or mistake, someone else is killed other than the person whom I wanted to kill because he had provoked me in such a grave manner that I lost my all senses. Okay, then that won't be treated like a murder. It shall be treated as a culpable homicide only, which is not murder. Okay, now provocation, which we are discussing, must be grave. Okay, it must be grave. We can have an example. A is going with his sister in market. B comes and pulls the wheel of A's sister. A confronts him, but B again repeats the act at the spot and holds the sister by hair, etc. A is provoked gravely and ends up killing him. Okay, now A is going in the market with his sister. Now someone else, probably maybe his sister's ex-lover, or someone who wants to have a relationship with the sister and sister is dejecting him, or someone who's just trying to eve tease a girl. Okay, he may be any person. He comes and pulls the wheel, okay, or dupatta, okay, wheel or dupatta of the sister. Sister raises a cry, and the A then holds that person and confronts him that how dare you do this to my sister? And then B is laughing, abusing, and he suddenly catches again his sister by the hair at the spot only and pulls her. Now, this is a case in which now A suddenly gets heated up. He loses his senses that how dare you touch my sister like this. Okay, he picks up a brick from nearby and hits it on the head of the bee twice, and bee dies. Okay, now there are ingredients of murder. Okay, now there are ingredients of murder. Okay, injury is there. Who has inflicted the injury? A has inflicted the injury to B. What is the nature of injury? Nature of injury is injury by brick. Okay, two, two injuries. Okay, two hits on the face with a brick, with a cement brick, which is sharp brick. Okay, on from the corner point of the tip of the brick. Intention to inflict that injury. Yes, he wanted to teach him a lesson, and he gave that two hits on the face of the man. Injury is sufficient in ordinary course to kill someone. Yes, if you hit someone's head with a brick twice with your full force, definitely if medical aid is not given in time, the person will ultimately die. Okay, so now all the ingredients of murder are there. Okay, but law says that we will treat this case as an exception because he was provoked so much. Because the one who died provoked him, provoked A, the one who killed him, in such a manner and in such a grave manner that A was charged up, he was heated up, he lost his senses. In such a case, when I am going with my markets, in market with my mother or sister, and somebody does this, you do not think anything. Suddenly there is a rush of hot blood, and you end up throwing anything which you have. The first piece you find, you throw at the person. Okay, and now person has died. Now all the ingredients of murder are there, but definitely law says because he was acting in the grave provocation. Okay, acting in the grave provocation. Now let's go back to mens rea and actus rea. Two ingredients of the crime that you should have a guilty mind as well as a guilty act. Now guilty act is there. Okay, even a guilty mind is there. He wanted to inflict that injury and inflicted it. But law says when someone is provoked with grave provocation, in such cases we cannot expect a man to make a rational decision. We cannot expect a man to make a rational decision at the spot. Okay? Because mind loses its control, body takes over, and a person ends up doing something. So in such case, now he hits a brick. Suppose he throws the brick. Okay, he threw the brick and he dodged, and big brick hit someone else, D, who is just standing and watching. And that person dies by accident or by mistake. Now, even that case will be covered as culpable homicide, not at all murder. Okay, so because law says when you are acting, laboring under a grave provocation, when the provocation is of such nature that you cannot think beyond anything rather than committing the crime which you committed, then we will believe that you did not have rational thinking. Plus, now it has to be sudden. Okay, the provocation has to be sudden in nature, at the spot. Provocation was at the spot. At the spot means that between this grave provocation and killing, between this grave provocation, when A was provoked gravely, and killing, between these two events, there should not be enough time. Okay, there must not be enough time gap between provocation and killing. Okay, there should not be enough time. Now, what is enough time? We can usually assume not more than 3 to 5 minutes. Not more than 3 to 5 minutes difference should be there between both the acts. Grave provocation and death. Because it should be sudden. Sudden means sudden. Okay, you cannot call something a sudden which is happening after a delay of 15 minutes. Okay, which is happening after a delay of 15 minutes. Now let's come back to this example again. A, okay, same thing has happened. Now what A does, A takes his sister, he goes back, drops his sister to the market, to his house, and then returns and then hits B with the brick and B dies. Now this case will not be a case of grave and sudden provocation. There may be a grave provocation, but the provocation is not sudden. For exception, we want a provocation which is grave and at the same time it is sudden. Provocation is grave plus sudden as well. Law says we are giving you an exception only because when you are provoked with a grave provocation, we cannot expect a man to make a rational decision. But if there is a sufficient time gap between provocation and killing, it means the person had option to think rationally. Now this person goes back, drops his sister at the house, comes back, finds B and then kills him. Now in this case law says because you have taken some time, okay, there is some time which has gone by between the two incidents. Meanwhile, you should have thought rationally because now grave provocation you are cooled down. Okay, you have taken a gap of 10 to 15 minutes between both the acts. That means you had 10 to 15 minutes. There was enough time for you to think rationally and cool down. You could have approached police or you could have approached B's father. Okay, or you could have done so many other things rather than simply going back and executing B. Okay, so if you do something like this, if there is sufficient time gap between a grave provocation and the act of killing, okay, then we will not call it a grave and sudden provocation. We will only call it simply a grave provocation. Okay, and in such a case, you could have definitely gone to police authorities. Okay, but you chose to come back and kill. That is not sudden. Now it becomes murder. Okay, it becomes murder if a person has sufficient time to think over the act. If something is happening spontaneously at the spot, it will be culpable homicide only. But if something is happening with a time gap in which you can make a rational decision, then law expects you to make a rational decision. And if you fail to make a rational decision, then that means you are at fault and now you cannot take this exception and you are guilty of committing murder. Okay, there should be no time gap between the provocation and the retaliatory action caused due to that provocation. The accused cannot take the plea of sudden or grave provocation if the death has been caused due to well managed plan and the main aim behind provocation was to commit murder. Okay, if you are doing something with the plan, it will not be called a grave provocation or a sudden provocation. Okay, and the provocation has to be grave as well. You cannot call every provocation a grave provocation. Okay. Now, a few weeks back, India celebrated Diwali. In Diwali, what happens? Some naughty students, okay, some naughty students, I would rather not call them naughty, I would rather them not law abiding, okay, students which do not follow the rules or regulations of the school, okay, which require disciplinary correction. What these students do sometimes, they place bombs in toilets or some other places and then light them up, okay, and the bomb blasts, okay. Bomb blast is not like blasting the building off. I think you are getting what I say, okay. The bombs which are sold in Diwali, okay, sold in Diwali. Okay, people blast those bombs in schools, canteens, in the rooms, in the toilets, and you are not allowed to do that in the school. But some people, some students who are not disciplined enough to follow these rules, they do act into these things. Now, suppose A is a person who is putting a bomb in the toilet, okay, and B, who also goes to a toilet at the same time, sees he has seen A placing the bomb there and lighting the bomb off. Now he says to A that I am going to report to the authorities, and he goes and reports to the principal. Now principal calls the parents. Okay. Now parents have to listen because of the act of the student. And now this person is angry that why did you report it? And then he kills him. This is not a grave provocation. Okay, or there is a fight between two people. They both are abusing each other. Someone ends up abusing somebody's mother, and he took it on the head. That how dare you abuse my mother or say something to my sister, something like this. And then he ends up killing. We usually don't call that provocation a grave provocation. Okay, a grave provocation must be a provocation in which something substantial is done, which makes any rational person to take the same decision, okay, which depraves the mind of any rational person. So if someone abuses me, people are abusing each other every day, okay, that doesn't mean people will start killing each other. No, people do not kill each other on merely abusing. Okay, it has to be someone grave, something grave, like I gave you an example, going with a sister, repeatedly touching your sister inappropriately in the market, saying something wrong about your sister, that is called a grave provocation. Okay, but merely arguing with you or abusing you or something like this or complaining against you, someone goes and makes a complaint against me in the police, maybe a fabricated and false complaint, but I am so agitated that I end up killing him. That is not a grave provocation which the law talks about. Okay, grave provocation is something substantial, like we give an example, like we discussed an example, something substantial which happens there. Okay, which happens there, and suddenly it happens. Okay, suddenly it happens. Private defense of person and property, we discussed that private defense, you are allowed to do private defense of your person and your property, and while doing your private defense or private defense of the property, you end up killing someone. Okay, you end up killing someone. Now you must be thinking that in the class we discussed, previous classes we discussed that in order to save someone's life, okay, you can kill someone else. Okay, that is a case of saving someone's life. But now someone is beating me. Okay, someone is beating me with his fist. I have a right to private defense, but we discussed that private defense is proportionate. Okay, it has to be proportionate. Okay, but now in my genuine private defense, I exceeded my right to private defense. I inflicted more injury than what was required. Okay, I inflicted more injury and the person died. But I did so while I was exercising my right to private defense or the defense of property. Okay, in such case, if when I exceed my such right, then also law will treat it as a culpable homicide, not murder. Okay, but if you are making a pre-planned and well-managed murder, then you cannot call it a culpable homicide. Any act which leads to killing of another person, but the same is done with a deliberate planning, okay, and detailed execution plan. Cold blooded murder, we call it. Okay, you poison someone, you plan it. Okay, when the person will come, he'll take a drink, he'll die within this time. This poison is required. You procure a gun, you go and buy a gun, make a planning at what spot I will kill him. You make a call from a different number, call him somewhere. You do things like this. When you are doing something like this, it is ultimately going to be murder. Whatever exception you would like to claim, law will not allow you any exception at all. Okay, but sometimes there is, I'm trying to protect myself, like my car hits another car. My car hits another car. Out of another car, two young boys come out. And they start slapping and kicking me. One of them took out a hockey stick. I somehow snatched that hockey stick and I hit him on the hand and he dies. Now, you people must be thinking that he was having a hockey stick. He could have killed me. Okay, he could have killed me. So, when someone is about to kill me and if I kill him, then there is no wrong at all because I have exercising my right to private defense. But you see the situation here. I have snatched the hockey from him. Now he has become powerless. I have the power. The power of hockey is with me now. I can give those hockey blows to him on the lower part of the body and he will run away. But I straight away hit him on the head. Intentionally, I hit him on the head. The all ingredients now are of murder. Okay, but because I'm trying to it I exceeded I was what I was trying to do in this case. I am just trying to exercise my right to defense. I am trying to defend myself, but now what I have done, ultimately I have exceeded my right to private defense. Okay, I have exceeded my right to private defense, but that shall not count as a murder. It will remain a culpable homicide only. It won't be treated like a murder. Okay, it will be culpable homicide. Why? Because law gives me an exception in such scenarios. Public servant acting for the advancement of the public justice. The action of a public servant working for the advancement of justice cause death of any person during rendering the public service, then the public servant will not be liable for murder but only for culpable homicide. Okay, only for culpable homicide. Now I have gone to arrest someone. Now, I am a constable. Okay, I have a lathi in my hand. Lathi is usually a hard bamboo stick which police people carry with them. Okay, a cane stick, hard wood stick. They have police people usually have with them. Okay, I have to go and arrest some person. Now I am going to arrest the person, but his friends have come up. Okay, they have surrounded me and they are not letting me arrest the person who has broken some law, and now he is running away. And I have full apprehension that the person, if he runs away, will be difficult to catch again. Okay, and friends are have surrounded me. They are not letting me go anywhere. They are not letting me make an arrest. I have a lathi. So in order to make an arrest, I have to now disperse the friends. Okay. So now in order to disperse the friends, I took my bamboo stick and I hit someone on the head. I give a very forceful blow on the head. The person dies. Okay, the person has died. Now the injury is sufficient. One strong blow on the head with a bamboo stick, with a hard bamboo stick, is sufficient to kill someone in the ordinary course of nature. And now I have done it intentionally. I am the one who has caused the injury. Injury is sufficient to cause someone's death. Okay, it has cracked open the skull, and I did it intentionally. I gave it intentionally on the head. I could have given it on the leg as well, but I intentionally gave it on the head. But now I was acting in the discharge of my duties for the advancement of the public justice. Okay, so in these cases, I will fall in the exception. Exception number three, which says public servant acting for the advancement of the public justice. Therefore, my act in such case shall not be treated like a murder, it shall be treated like a culpable homicide alone. Okay, and I shall be given a lenient view while I would be sentenced. Okay, but we should not confuse it with the case of encounter. We should not confuse it with the case of encounter. Case of encounter is completely different. Case of encounter is a case in which the police is in a life and death struggle with the person they want to arrest. He is also shooting at the police, police is also shooting at him. So in such case, if he is dying, okay, if someone dies in the encounter, then there is no offense at all, not even culpable homicide. Okay, because now police is exercising its right to private defense, because the other person is able to kill the police if police doesn't defend themselves. He is shooting at the police, police shot back at him, he dies. That is a case of encounter, open and shut case, no offense at all. But this is not an encounter. Here the friends are not trying to kill the constable. The friends are just trying to resist the arrest. They have surrounded the policeman, they have restricted his movements, they are not allowing him to move. Okay, the friends are not trying to kill the policeman or kill the constable or hurt the constable. They are only trying to prevent him from arresting the man, and he hits them. So, this is a case different from the case of encounter. So, in this case, it shall be treated like a culpable homicide and not murder. But the case of encounter is completely different. If someone is if someone dies in an encounter with the police, then no offense at all. Police has not committed any offense at all. Death in a sudden fight. Okay, death in a sudden fight. In a serious fight of two parties means there are two people where they are fighting with each other, or more than two people. Okay, two sides are there. Four people from one side, eight people from another side. All 12 people have collided with each other. They are now fighting very badly. It's a case of serious fight. Okay, suppose this fight is happening in a restaurant. Someone is throwing a water jug at someone, someone is throwing a glass, someone is throwing a chair, someone is beating someone on the table, like you see in the movies. Okay, someone is throwing someone out of the window. It is that kind of fight we are talking about. Serious fight, not a fight in which two people are holding each other's collar and threatening that I will beat you. You raise your hand first, I raise your hand first, you raise your hand first, or you raise your hand first. This is not that kind of fight we are discussing. Okay, which usually happens. Okay, people keep on abusing each other and don't do anything. But this is the fight which is a serious fight. People are actually fighting with each other. Someone is having a hockey stick, other one is having a rod, other one is having a wearing a punch, someone is having a dagger, and something like this. Okay, in a serious fight of two parties, causing death of one of the party due to the action taken by the accused party out of anger and sudden provocation. The principle is again same. Principle is sudden provocation, because in serious fight you are provoked. Okay, if I am sitting with two of my friends, two three people come there, suddenly some of them is having a hockey stick, they start beating us, we are now provoked. Okay, we are also provoked, we will also do whatever is possible in our our hands, whatever is possible with us we will do in order to beat them back, or to you know defend ourselves, whatever is possible. And if someone dies in such a case, in such a serious fight someone dies, then it shall be treated as an exception to murder, and you will not call it a case of murder, it will be a culpable homicide alone. The accused will be liable only for the culpable homicide and not for the murder. Both the parties are held equally liable for the provocation of the fight. Now, both the parties are liable for provoking each other. The aggrieved cannot take the plea that the provocation was made from the accused party. The important point here to ponder about is the action must be sudden and unpremeditated. Okay, the death must have been caused out of anger. The main point is that it should be sudden. It should be a sudden fight. Okay, it should not be a planned fight. Okay, that you two go start fighting, then they will fight with us, and then I will kill him. Okay, and then I will kill him, and I will then claim the exception. I'll go behind the bars for 10 years, no issues. I can go for, I am willing to go in behind the jail for 10 years. Okay, but let us plan it in it the murder in such a way that it looks like a culpable homicide. It looks like a sudden fight. No, if this is shown, then you are definitely going in for the life. Definitely, if someone is doing this, he is definitely committing a murder, and the minimum sentence is life imprisonment. If you are planning the fight like this, no, it has to be a sudden fight. Okay, it has to be a case of sudden fight. Death by consent. If a person who is above 18 years of age gives consent voluntarily to undertake the risk of life in the hands of others, then the death caused according to the wishes of the deceased. The person will be liable only for culpable homicide and not for the murder. The provision reduces the extent of criminal liability of the person. We can take the example of mercy killing done with euthanasia, which is illegal in India. Euthanasia is also called mercy killing. Mercy killing means someone is so badly disabled. Suppose his both kidneys have stopped functioning. He is bedridden. He is alive, but he cannot live the life. He cannot enjoy the life. He is alive, and doctors say we will keep him alive for next 5 to 10 years by operating him every month. Now this person says I have no chances of revival. Suppose this person is my relative, my father, my mother, my husband, my wife, my daughter, my son, my this and that, and they plead with me that please you kill me in a painless manner. I just don't want to live. Kill me in a painless manner and this and that. And I give poison which causes a slow and painless death, and the person has died. Now, this case will not be treated like a murder, though I have done it intentionally. I intended to kill him, and I killed him. Probably I would have planned as well. I would have gone to the market to buy some poison which is not painful and this and that in order to administer that poison to that person. But because the death is happening because the person consented for the death, because the person has consented for his death, and I am killing him, a kind of a mercy killing. Okay, with a heavy heart, I am killing him. This kind of killing will not be a murder. This kind of killing will only be a culpable homicide. Okay, but the person who is giving you consent should be above 18 years of age, should not be of unsound mind. Okay, he should not be of unsound mind and should be above 18 years of age, because 18 years is a minimum age of consent. If any person who is below 18 years of age, he is giving any consent to committing any crime with him, that consent is not a valid consent in the law, and you will be one the who is acting on that consent will be completely liable for committing the crime. Okay, and the person should not be also an unsound mind, because an unsound person, a person who's lunatic, a mental mad, he also cannot give a valid consent. When someone cannot give a valid consent, you cannot validly act upon such a consent. Okay, because such consent is vitiated by lack of mental understanding for giving consent for such act. So these are the cases which are exceptions to murder. In these cases, in these categories, if someone is committing a murder, okay, in these categories which we discussed, then his case will be treated not like murder, but only like a culpable homicide. And there is a day and night's difference between sentence which murder carries and the sentence which a culpable homicide carries with it. Okay. Honor killings. Now you all understand what are honor killings, murder or culpable homicide. What is honor killing? A murder or a culpable homicide? Honor killing is usually when people marry intercaste or interfaith marriages are there. A Hindu is marrying a Muslim is marrying a Christian. Okay, or a Brahmin is marrying a Sudra, or a Vaishya is marrying a Kshatriya or something like this. So people are marrying who live in the same village, they are marrying each other. Or somebody is marrying his own cousin, somebody is marrying his uncle, somebody is marrying his nephew or niece, like this. These cases happen a lot in India, and then families are outraged. Families are outraged. They feel that our son or our girl, they have put a blemish on the honor of the family. They have brought a dispute to the family. Okay, we should remove this. We should remove this smudge. We should remove this black mark put by the son or the girl. Then they end up killing them. What is it? Is honor killing a case of culpable homicide? Can we say honor killing is a grave provocation? Grave and sudden provocation. Okay. Or do we call honor killing a murder? Let us see what our Supreme Court says. The Honorable Bench of Supreme Court of India, comprising of Justice Markandeya Katsu and Justice Kyan Sudha Mishra, stated that there is nothing honorable in honor killings. Supreme Court, the apex body of justice administration in India, says that there is nothing honorable in honor killings, and the person indulged in these type of crimes should be awarded capital punishment. Okay, should be awarded capital punishment. He should be capital punishment means death sentence. Okay, capital punishment is death sentence, execution by the state. So a person who is guilty of committing an honor killing should be deserves capital punishment. Honor killings is considered as the rare of rarest crimes in India. They are very rare crimes in India, rare of rarest, very grave crime. If anyone is not happy with the relationship developed by his or her daughter, then one is free to cut off all the relations with her. But one cannot take law in his hands to commit such crimes. Okay, this is what our Honorable Supreme Court says, that there is no honor in honor killings. Okay, so a case of honor killing will not be treated like a culpable homicide. It will be treated like a murder. Let's do some case readings regarding the exceptions of murder. Muthu vs. State 2007. Case where a man every day litters in front of a man's restaurant. A man is having a restaurant. Other man, littering means throwing garbage. Other man is throwing garbage in front of that restaurant. and the restaurant looks untidy due to that garbage. And to these visitors are not interested in coming to the restaurant. They feel that restaurant is unhygienic because restaurant is in a dirty place. So definitely he will be unhappy with the man who is littering in front of a restaurant, continuing the same act for a long period of time. After repetitive warnings, the restaurant man shot him dead. Okay, the restaurant man shot him dead. It was held that every day littering filled inside the restaurant man anger, and the day of the incident he was suddenly and gravely provoked, and hence it is an exception to section 300. Honorable Court held that this particular act of littering in front of restaurant, continuous littering, even after repeated warning, filled a man with anger. Okay, there was anger in the man. And on the date of incident, when this man again came to throw garbage, despite so many warnings, then this man, the one who killed him, was full of anger till the tip of his head. So he ultimately ended killing him. So the honorable court held that this kind of cases will be covered in the exception to section 300, and we will not treat such killing as a murder, but we will treat it as a case of grave and sudden provocation, and hence it shall be treated like a culpable homicide not amounting to murder. KM Nanavati versus State of Maharashtra. Akshay Kumar recently made a movie 2 3 years back that is called Rustam. Rustam movie of Akshay Kumar, based upon this real incident. If you people have seen the movie. KM Nanavati is a sailor. Okay, he is on the sail all the time, on the boat, on the ship. He comes back and he finds out that his wife is having an illegal affair with some other man, with his friend. Okay, on finding about illicit relations of his wife, Nanavati goes to Ahuja's house and fires 3 rounds of bullet. The defense of section 300 exception 1 was taken that on finding about his wife, Nanavati was gravely and suddenly provoked. Now what Nanavati did? Okay, let us see what Nanavati did. Held he is guilty under section 302. Court held that he is guilty of committing a murder. Okay, the defense lawyer. The defense lawyer means a lawyer who is trying to protect Nanavati. He says that the act of the Nanavati should be taken as an act of grave and sudden provocation. It should not be treated like a murder. It should be treated like a culpable homicide, and less sentence should be awarded to him. Why less sentence should be awarded to him? Because he was acting under a grave and sudden provocation. When a man comes to know that his wife is having an illegal affair with his friend, he is gravely and suddenly he will be provoked, and he will not be able to make a decision, and he will ultimately end up killing. So court agreed that yes, this is a kind of grave provocation. Provocation in such case is grave, but court was not convinced that the provocation was both grave and sudden. Court held that yes, the provocation was grave, but it was not sudden. And because it was not sudden, the act becomes a planned murder. Okay, act loses its character of a culpable homicide, and act takes the character of a murder. Now, why did court come to conclusion that act was not a sudden act, it was a thoughtful and planned act? Let us see. Court held that he he is guilty. Who is he? He is Nanavati is guilty under section 302. 302 is punishment for murder. Court laid down reasonable man test and time gap. Court laid down what a reasonable man would do in such a situation. Court said yes, a reasonable man would be gravely provoked. But what about the time gap? After knowing about his wife, after Nanavati comes to know that his wife is having an illicit relationship with Ahuja, he performed all the duties of a reasonable man. He took his family to cinema, he took his wife to cinema, drove to Ahuja's place. Okay, and then he went to his ship. He took his gun from there. He went to Ahuja's place, and then he shot Ahuja. That means there is a gap of 10 to 12 hours between knowing of the illicit affair and killing of Ahuja. Court says for 10 to 12 hours, Someone cannot be provoked gravely. We cannot expect someone was so lost in his senses that for 10 12 hours he could not think of anything else than killing a man. So within 10 to 12 hours he had a time to think over his act, and if he could have thought over his act, then he should not have done it. Okay, and it was a planned murder. Okay, after 10 12 hours of knowing that thing, then it is not culpable homicide, it is a murder. R. Ahluwalia. R versus Ahluwalia. Wife suffered domestic abuse for almost 10 years. Okay, Ahluwalia was beating the wife for almost 10 years. One evening, her husband threatened to beat her and burn her with a hot iron, forcefully demanding money from her. Okay, one evening, husband said that I will beat you and burn you with a hot iron if you do not bring money, dowry money from the house, from your matrimonial house, sorry, parental house. Afterwards, they went to sleep. However, wife woke up. Sorry. However, wife woke up in the middle of night and poured caustic soda and petrol that she had bought few days ago in a bucket. Okay, she had bought petrol and caustic soda few days ago. She put it in bucket. She further proceeded to throw the bucket in her husband's room. She went to her husband's room with a bucket, and
It's 10
bucket is
o'clock.
having that mixture along with a burning stick, which resulted in him sustaining severe burns. Now she burned her husband alive, okay, leading to his eventual death after 6 days of incident. She was convicted for murder. Okay, she was convicted for murder. It was held that Kiranjit's response was the culmination of years of abuse, which does not fall within the definition of sudden provocation, and thus her defense failed. She had enough time to cool down, and hence is not a grave and sudden provocation. Okay, Kiranjit said, court held that what she suffered was for 10 years she was suffering, and the anger was a result of 10 years suffering. It was not a sudden and grave provocation. This same thing was happening with her for 10 years. Okay, for 10 years, and she did it with planning. Okay, she bought a caustic soda, petrol. She bought it few days back. That means she had planned to kill her husband someday. Okay, she had enough time to cool down, and hence this is not a case of grave and sudden provocation. The following three elements need to be established in order to prove diminished responsibility. Okay, following three elements are required to prove to take the benefit of grave and sudden provocation: an abnormality of mental functioning caused by a recognized medical condition, okay, which provides an explanation to the acts or omission of the defendant, that the mind started functioning abnormally upon that grave provocation, which has substantially impaired his or her mental ability to understand the nature of actions from a rational judgment or exercise self control. That person could not exercise self control because of that grave provocation. In this case, the defense of diminished responsibility within the meaning of homicide was used at the later stage during the retrial, as no evidence was produced at the trial court. However, this final ground of appeal was successful. Okay. Finally, ultimately, she was treated as only she was convicted only for culpable homicide, not for murder. Okay, her case, this is initially she was held for murder. Later on, her case went on to Supreme Court. Later on, Supreme Court called her guilty for culpable homicide only. Okay, because it was just like this case. This case was just like this, where every day something was being done by her husband, and she was full of anger. But one day, suddenly her anger was so much that she ended up killing. So court held that this was also a case of culpable homicide. So now we are done with this. In next chapter, we'll meet in next lecture. Sorry.